Hey friends, come on in. We're going to talk about the best news ever today. Come on in, join this live session. And as you're coming in, type in freedom now, freedom now, freedom now, freedom now. Let's go. McBean Immigration TV. This is the day that we've got to get together. We've got to come together and talk about the historic moment that we just watched, right? If you just saw the announcement from the White House about the new pathway to lawful status that President Biden has created, type it in now. I was watching, I saw it. Lots of people were there. Lots of people were there. We weren't there though. We didn't get an invitation. Nevertheless, this is the day that the Lord has made, and we are rejoicing in it for all of those people who will be helped by this new lawful status. I'm going to break it down for you. I'm going to answer your immigration questions, but I'd love to feel your energy. I see that you're here now. Freedom now, freedom now. Type in freedom now. Type in freedom now, guys, as you're coming on board. And let me know where you're watching from today. I'm Latoya McBean Pompey, an immigration lawyer in New York. Yep, folks are saying they just saw it. They just saw it. Folks are, we're here in New York, but we work with folks everywhere, all over the United States and in many different countries. And I have some breaking immigration news to share with you today. We've been talking about this for the last few weeks. Now it's official, thank God, right? They actually came through. They came through for the 500,000 estimated folks who will be helped by this. In addition to stepchildren, I'm going to break it down for you. DACA holders, dreamers, there's something in here for you as well. So let's get into it. Our contact information is scrolling below. For those of you who'd like to get in touch with us to talk about your immigration problems, get on our website, McBeanLaw.com, or call our office at 888-462-4006. But let's talk about what just happened. Today, President Biden created a new action for spouses of U.S. citizens to be able to get a lawful status in the United States. And through this status, friends, it comes initially as a work permit. Here you have a 3-year work permit under this new Parole in Place program, very similar to how this Parole in Place policy or program works for military family members. So U.S. citizen spouses who have been here for at least, who have been in the United States for at least 10 years, who did not lawfully enter the United States, will be eligible for this. And I'm going to pull up the information on our website, but I want you to consider this, guys, that we're talking about a 2-step process. It's not a slam dunk, and I want you to know that from the very, very get-go. This is not a slam dunk. It's a 2-step process. The first step would require getting this PIP status, and then the second step will require adjustment of status. And that's where the deal happens. That's where the green card happens for those who are eligible to go all the way to the finish line, to the green card. So let me do this. Let me pull up. Hold on a second here. I'm going to get onto, let me get onto our website just so that you could see this for yourself. We have on our website a terrific blog that our team put together that breaks this down for you. So go to McBeanLaw.com/parole, okay, Parole. And here you will learn more details about this, how this is going to work. And to be eligible, friends, let's just go into it right now. To be eligible, first of all, you must be legally married to a U.S. citizen as of June 17th, 2024, yesterday, okay? Yesterday. So for all of you who are asking, oh, what about me? I'm planning on getting married tomorrow. It's not going to work out. Not going to work out for you. You must have been married as of yesterday. Also, friends, you must not pose a threat to our public safety and national security. they're going to run your background. You're going to have to go through a background check, and you cannot have any disqualifying criminal history. You must have a pretty clean history, okay? And I'll talk about waivers towards the end of this presentation. But you must also be here present, physically present in the United States at this time without having been admitted lawfully by customs or paroled into the country through like a humanitarian parole that is given at the border. You must have continuously been present in the United States for at least 10 years as of yesterday. Okay, so you need to have that 10 years on your record. And certainly the last thing that I really want you to keep in mind is the fact that this is discretionary. The government will still size you up and make a decision about your PIP application. All right, so this is an application process that the government will be rolling out at the end of this summer. We do not have the date yet. The Federal Register has not been published as of like right now with those details. What we know, President Biden even mentioned it himself, that this is at the end of the summer. They will be rolling out this application process. Now, the application process will be through USCIS, of course. It's gonna require some evidence, some documents to prove things like your identity, your marital status or relationship, not bona fides of the marriage quite yet, but just the basics of your identity, your marital status, your residency, how many years you've been here. You'll need to have that evidence to show that you've been here for at least 10 years. So the documentation will be needed. You pay a fee. And again, on a case-by-case basis, they are going to make this process, this PIP available to you. Now, stepchildren are also eligible. Okay, so 500,000 undocumented spouses of U.S. citizens, in addition to 50,000 non-citizen children under the age of 21 whose parent is married to a U.S. citizen, are also eligible. Okay, so the stepchildren can also come in through this process, get a green card through this process down the road as well. However, they must have become a stepchild. The step-parent-stepchild relationship must have formed as of yesterday, June 17th, 2024. Okay, so those are the key highlights. Again, go to McBeanlaw.com/parole to get those details. Read it for yourself. There's also another document the government issued yesterday for those of you who said, well, I like you, McBean, but I need something a little bit more official than that, okay? I don't want to just go to McBeanlaw.com/parole. Well, what you can do is you can go to DHS's website, okay? The Department of Homeland Security published yesterday the fact sheet on this parole program. It's a little challenging to kind of sift through, but it includes all of the information that we've shared on our website. We've just simplified it for you. So you could find this at dhs.gov. Okay, they've put this out and they've indicated what those requirements are on this website as well. Okay, and the fact that the application period, it says it right here, friends, the application period begins later this summer. Okay, and USC, if you try to apply for this before they publish the date of when the period opens up here for your application, they will reject it. Okay, they will reject any filings or individual requests received before the date when the application period begins later this summer. And so go to DHS for this information as well. So great news. Again, parole in place. First step, PIP, which will give you a 3-year work permit. The second step is to apply for adjustment of status within the 3 years. Now, when you apply for adjustment of status, the government wants you to keep some very crucial things in mind. You will not be eligible to get the green card if you have a criminal history that that is pretty much a bad history. Okay, that's just putting it lightly. But if you have a significant criminal history, you could be disqualified. However, some individuals, depending on what is on their record, some individuals will qualify for a waiver, the I-601 waiver, which will help them to cross that finish line. If you have the permanent bar, if you have multiple entries, unlawful entries into the United States, you will not be able to get through using this new legal process. If you have false claim to U.S. citizenship on your record, likewise, you will not be able to get the green card through this process that the Biden administration has created today. These only if a waiver is available currently for individuals who are going through adjustment of status, will you also likewise be eligible for the waiver. All right. So let's talk about your questions. Okay. I'm going to pull up your questions. Type in freedom now, if you're enjoying this. Freedom now. Again, everything, the cutoff date for this is as of yesterday, July 17th, 2024. Freedom now. Freedom now. Okay, we're going to do this now. Let's get into some top questions that we've received, and then I'm going to turn it over to you in real time to answer any real-time questions that you have. Here we go. So the first question is this that I received from you. Can you tell me whether this Biden waiver plan can help people who are waiting for the I-601 waiver outside of the country? This does not help you if you're outside of the country. The rules say on DHS website that you must be physically present in the United States without admission and without parole. Let's see. Second question. Let's go here. I'm using a wireless mouse. Guys, I'm using a wireless mouse here, and it is slightly different from what I'm used to, so bear with me. Okay, let me just, okay, there we go. How about those who came in with a visa and fell out of status? Or is this only for those who entered without a visa? So if you entered with a visa lawfully and you're out of status, the government already has a pathway for you. You can adjust your status if you meet all of the other eligibility criteria. This specifically helps those who entered without without lawful entry. Okay, next, let's go here. Okay, so the next question is, will it benefit those who have been deported and are married to a U.S. citizen? Again, if you are outside of the United States, this is not your process. This is not for you. You must have been physically present in the United States all these 10 years continuously, and you must still be here as of yesterday. Okay. Does this apply to I-130 approved cases, but I have a pending I-485. So this person has a pending adjustment of status application. This doesn't apply to you because if you have a pending adjustment of status application, you have a burden of proving that you entered, of how you entered into the United States. You must show them that you were either admitted, inspected, or paroled into this country. And so if you have successfully done that with your pending case, then you should be fine to get your green card, okay? Unless something else comes up on your record. What if you married last year, but you've been here for the last 15 years? Well, if you got married last year, this will help you because the cutoff to have been married was yesterday, okay? What if I have DACA and I filed for the I-601A waiver? Can I still file for this parole in place? Yes, you can. And in fact, I forgot to mention on McBeanlaw.com/parole, we have some FAQs, frequently asked questions, only frequently as of yesterday, right? But we have some frequently asked questions in which we do talk about the I-601A waiver. So go check that out. But in this session, I will tell you that, you know, if you were my client, so to speak, I would tell you, you have an opportunity to get a green card now through this process. Why wait 3 or 4 years on an I-601A waiver and take the risk of leaving the country, not unless we've already determined that your risk level is low go and you can leave. So if you have DACA and you filed your 601A waiver, depending on whether that waiver is already approved or if you're already at the NVC, it's a timing issue and how close you are to the finish line. If you're close to the finish line, then finish up. But if you're not close to the finish line and this application period opens up at the end of the summer, I would say try to do the next step in this PIP process. The next question is, would this program help with prior convicted felons who have been here for about 20 years with U.S. citizen spouse? So you're going to have to, through this program, as I've described, you're going to go through background checks, and there are disqualifying criminal, history. So you might be disqualified from this. It depends on what's on your record. Next, what about those who submitted applications for their 10-year green card and are now having problems with their spouses? So you'll need a consultation with maybe us, okay? Let me go back to, oops, my mouse has taken over. Let me try to get back to, okay, here we go. What about those who submitted their application for the 10-year green card but are now having problems with the spouse? Get a consultation to discuss what those problems are and whether or not you're eligible to move your case forward on your own. But you will not be eligible for this PIP unless you have a spouse, U.S. citizen, and you're in a genuine marriage with that individual, and also that person is going to be with you till the finish, okay, to the finish line, okay? What if a spouse is not a citizen yet, but will be in about a year? Will they benefit from this PIP? No, because you must have been married to a U.S. citizen as of yesterday. And if you're only married to a green card holder, well, you're disqualified from this program. What about us that are already on consular proceedings? Brenda's asking, will we be able to go to our embassy appointment here in the States? So if you're if you're at the National Visa Center, and this is on our website too, National Visa Center, FAQ, at McBeanlaw.com/parole, it depends on how close to that finish line you are, because if you've already been documentarily qualified and you're waiting for a date at the U.S. Embassy and this application process under PIP, this new PIP is not open yet, well, you might get an interview. You might get your date for an interview next week or next month. I don't know. So work it out with your lawyer as far as the timing is concerned. But if your case has just recently made its way to the NVC and you have a ways to go, well, transition into this PIP might be a very smart move. What about if you're the spouse entered many times and have a deportation because of DUI? So when you say that the spouse entered many times, I'm thinking maybe multiple unlawful entries, and that would trigger the permanent bar. So I would say no, this PIP will not help that individual. This is a removal question. Do people with voluntary departure who failed to depart and are married to a U.S. citizen for 11 years now, can they benefit from this? The answer is yes, actually, because if you had gotten voluntary departure in immigration court and you did not leave by the date when you told the government you would leave America, well, that converts into a removal order. And after converted into a removal order, you'll need to get your removal case reopened and terminated. So it's possible that with an approved PIP plus an approved I-130 together, you could take those approvals and seek a joint motion to reopen your removal case, take it to ICE, DHS, and see whether they will join you with reopening the removal case. And if you're successful with that, then you could finish your process through adjustment of status after that. So for those in removal proceedings, I want you to hear me clearly on this one, and you need to contact us. Okay? Contact us, because this is it's going to take some steps and skill to really get you through the finish line if you have a removal order and you're considering this PIP, okay? Next question is, what about a married spouse who is on DACA? Any information on how that transition would look like by this new parole program. Again, if you have DACA and you're married to a U.S. citizen and you do not have that lawful admission or parole, then you will be able to take advantage of this. Would parole in place exclude spouses of U.S. citizens with a single conviction of marijuana, possession of 30 grams? So if you have a controlled substance record, okay, conviction, you have to remember that there's only one waiver that is available for that single possession, 30 grams or less. So we would assess you for that waiver, and that waiver will become relevant during the adjustment of status process. Okay, guys. And so those are the questions that I had received. Also, I want you to know that there's another big and important part of what was announced today. It seemed like it was a smaller detail, but it's still significant, particularly to individuals who have who are dreamers, okay, or who are on DACA. For those who had earned a college degree, you're able to, and you have some sort of job offer. I've seen it reported, a high-skilled job offer. There's a waiver process that they're going to put in place, which would allow you to apply for a waiver and leave the U.S. and go to a U.S. embassy to finish the process abroad, okay? That's also in there for you as well. And what I'm going to do, just for your reference, I'm going to pull it up here on DHS's website, and I'm going to read it to you. It says, in addition, DHS will join the Department of State in an effort to more efficiently facilitate certain employment-based non-immigrant visas for eligible individuals, including deferred action for childhood arrivals, DACA recipients, and undocumented non-citizens, and I'm assuming they're referring to dreamers here, who have graduated from an accredited U.S. institution of higher education. By clarifying and enhancing the existing process, the Department of State's policy will give U.S. employers increased confidence that they can hire the talent that they need, and then that's that. Okay, so we'll take a look at how they're going to implement that waiver process to allow you to leave. Right now, we have the non-immigrant visa waiver, and we do those types of cases for people who are outside of America with violations on their record. And through this waiver, it sets aside their violations or criminal history or whatever the case is, or the fact that they were deported, sets it aside temporarily, which then allows them to travel in and out of the United States for a period of time under that visa. So I'm thinking maybe that's what they're going to be doing here as well, something similar to that. So friends, those are that's that. Okay, that's that. Let's see what additional questions you have for me. I think I covered the top news. Okay, Freedom Now. Thank you guys, Jacqueline. Let's see here. Freedom Now. Let's keep going. Let me know how you guys think about this. What are you thinking? Let's have that dialogue. What are you thinking? Someone says, can you mitigate the false claim to U.S. citizenship through a waiver process? Only if you're seeking the crime victims visa, and we do that waiver for crime victims with that case. So that's a very narrow opportunity that some people have. If you're seeking things like TPS, there is a waiver, but only for like TPS, not for the green card. So if you're seeking a green card, there is no specific waiver through a relative that can mitigate this problem of falsely claiming to be a U.S. citizen. My husband's waiver was just approved. That's the 601A waiver. They're waiting for an appointment in Mexico. What should I do? You could still wait. I would say, wait, right? Because the application is not yet open for this new process that is being created. The other thing that, and it seems like you're so close to the finish line there. The other thing is this, although at the end of the day, it will be a family decision whether he should leave or stay for this program. I had something else that I wanted to share with you about that. But yeah, let that be your personal decision. He's close to the finish line. He could, go. If he decides not to go, that's fine too. He'll just, oh, this is what I wanted to say. I wanted to say that we don't know what the process and time will be for this new PIP. Keep that part in mind as well. Yes, the Biden administration this year is doing some very fast approvals that we've been seeing, 3-month, 4-month adjustment of status approvals without interviews, approvals at the national benefits level. Yes, that's happening, but I don't know how quickly they're going to push through PIP, okay? What if there's an intent to deny an approved I-130? It sounds like, I don't know if you've also applied for adjustment of status with your case, if this is an I-130, I-485 case, whatever the case might be, you're gonna, in order to get a green card, you're gonna need an approved I-130. Okay, we work on those in notice of intent to deny too. So reach out to us, friends. Let's see. Give me a moment. Someone says through Super Chat that I-16, thank you for the Super Chat. I-601A has been approved. Any way I could do my interview here in the US? Yes, through PIP. Yes, if you are uncomfortable about leaving at the end of the day, then this is potentially for you. So let's see. Let's see if Biden could proceed with this executive order. Could he have saved the 11 million? No, he would not have been able to save the 11 million. To save the 11 million would require reform, congressional reform, okay? Congress would have to intervene and do something, change our laws. This is kind of like what happened with the parole that we've seen with other people groups, Ukrainians, Haitians, and some other groups. Those are executive actions. This process to get a green card through a U.S. citizen spouse is already in our laws. It's written. This only streamlines it. It says, well, these people are eligible under our law, otherwise eligible, by going to a U.S. embassy through a discretionary waiver process first and have to wait all these years, and it's lengthy and burdensome. So let's just streamline it a little bit and allow them to just do this, stay here and get their green card. Some will argue it's overreaching, that this will be challenged by Republican state governors. Of course, it will be challenged, just like DACA has been challenged in the courts for years now. So I'm expecting this to likewise be challenged. And we just have a couple more minutes together. Let me see what other questions I can take. Guys, my camera timed out on me. All right, but I'm here. I lost believe it or not, I lost the little piece that connects the plug and all of that. So it's on battery. Yeah. Okay, what if you're married but separated? If you're married but separated, I don't see how this is going to help you, because you're going to need your spouse's documentation and sign off on the adjustment of status part of things as well. So I don't think this is going to help you, okay? Someone says that TPS is a lawful, TPS is on the, you have TPS, that's a lawful status. And let's see, what if, let me go back up. Let's go back up. We discussed how this could help some people with DACA. They didn't do a whole lot today for DACA. We talked a little bit about dreamers being able to, and DACA holders with the waiver, being able to go to a U.S. embassy abroad to be interviewed. PIP can be denied. Someone says, can PIP be denied? If so, for what reason? Yes, maybe you didn't submit, maybe you don't meet the 10 years residency requirement. Maybe if documents were submitted that are fraudulent, scams. Certainly there will be scams related to this new opportunity. So it could be denied for fraud and misrepresentation. It could also be denied based on your your history, your record, because again, fingerprint is going to be done in with this process, okay? Let's keep going. Your immigration history will matter as well, but waivers are available. If you're married to a U.S. citizen and there's fraud on your record or misrepresentation, a waiver is available for you to argue that if you leave America, your spouse, U.S. citizen, will suffer extreme hardship. So you will still have that opportunity to make that argument during the adjustment of status process. Thank you. Someone says, I've been here for 40 years. I had multiple DUIs before the year 2000. Your case is going to have to be assessed by an immigration lawyer, looking at your criminal record very carefully to see whether or not you should move forward with this process. Let's see. Let's keep going. Freedom now, freedom now, freedom now. Someone says, if your case was denied, how can you proceed with the new order? Which case? What type of case was denied? Okay. Let's see. Let me go down. And we're going to wrap up momentarily. I do not have any updates on cancellation of removal. Cancellation of removal, aside from what I've shared with you a few weeks ago, the fact that the Biden administration last September moved to change the rules that would allow those of you who have been in the United States for at least 10 years, who are not in removal deportation proceedings, to be able to apply for cancellation of removal based on meeting all of the other requirements. That I would love to see happen because it would help a lot of caregivers and a lot of other individuals. That has not, that's not in effect yet. Okay, thank you. Okay, let's see. Marlon says through Super Chat that, what about my spouse with an in absentia order? So Marlon, your spouse who has this in absentia order would need to get that PIP approved first, get an I-130 approved next, and then get that joint motion to reopen approved by DHS ICE in order to get rid of this in absentia removal order and then be eligible to finish the green card process through adjustment of status. Contact us for that, okay? I-601A approved. Any way I could do the interview in the USA? Yes, I think I answered that one already. The answer is yes. The answer is yes. Someone says, let me see if I could get this question fully on the screen. What about documented immigrants who are married? I have a VAWA case, but I have never filed, been here over 10 years. Okay, so you have a DACA case. So you have you have a VAWA case. My apologies. She has a VAWA case. So you have a way. What am I missing here, Jamaican girl? Please break this down, okay? Tell me, ask it differently, okay? You say that you have a VAWA case. This doesn't impact those who have had applied for a green card through humanitarian means like VAWA. This isn't for you. This is only for spouses of U.S. citizens, and you're still in a relationship with this person, and they're going to sign paperwork for you with this PIP program. Okay, let's see. What else do you have for me before we go? Someone says, I am married to a U.S. citizen, but he has a felony. Can he still petition for me? In most cases, the answer is yes. In most cases, it's yes. There's some disqualifying crimes like crimes related to a sex offense, but in most cases, the answer is yes. So friends, I'm going to wrap up our Q&A right now. I will be live on TikTok, Instagram, and Facebook today as well, answering additional questions that those audience have. But I want you to know this is great news. It will help a lot of people. The application period will open up at the end of this summer, and this is going to be a two-step process: PIP with the 3-year work permit, and then during that 3-year period, you could apply for adjustment of status. If you have a complex immigration background, like you're in removal, it could still work, or if you have a removal order, this could still work. It will just take some skill and expertise, but you could still get to the finish line through this new legal status. Go to McBeanlaw.com/parole in order to see all of the requirements that we know so far that DHS has shared with us, or you could also go to DHS's website and read their fact sheet for yourself. Follow me on the let's see, I think that follow me, friends, on TikTok. I'll be live later today answering more questions. McBean Immigration Law, that's where you'd find me on all of the other social media platforms. I hope you found this helpful. Be sure to share this good news. And we are doing consultations. We're taking consultations about this right now, too. So if you've been out there following me for years and you always wanted to work with us, come on in. If you're eligible for this, we would love to tell you you're eligible and do it for you. It's a two-step process. We will do both steps for you. If you need a waiver, we will do the waiver for you as well. And if there's removal, we will help you with that aspect as well. Okay, so reach out to us at McBean Law at 888-462-4006 so that we could start talking with you about this new legal status that President Biden has created, an open door for some of you. So guys, thanks so much for being with me today. It's been my honor and pleasure to be with you, and I will see you in the next one. Bye-bye.